District Court, Adams County, for October 30th, 2023. We'll call up case of the people of the state of Colorado v. Nathan Woodyard, who's here with his counsel. Prosecution's representatives are present as well. All right, anything before we get started?
What did the court want to address this afternoon?
Motion for judgment of acquittal.
That seems like a good place to start.
All right. On behalf of Mr. Woodyard.
Thank you, Judge. Judge, Mr. Woodyard is moving for, pursuant to Rule 29, a motion for judgment of acquittal. I know that this court is well familiar with the standards. However, even in the standards slated towards the prosecution's favor, it's clear that there is no other ruling that's appropriate other than granting the motion for judgment of acquittal. Understanding that that the court must determine all the relevant admissible evidence, both direct and circumstantial, and they must view it in the light most favorable to the people. The court has to determine that that evidence is substantial and sufficient to support a conclusion by a reasonable mind that Mr. Woodyard is guilty of both manslaughter and criminally negligent homicide. What's important with both of those charges, Your Honor, is that the people have to have the evidence to show that Mr. Woodyard caused the death of Elijah McClain. Throughout this entire trial, the court heard, with respect to the cause of death, without the ketamine, there is no death. Here, no one has identified any action by Mr. Woodyard as the cause of death to Mr. McClain, and that's important. There has been much testimony as to the actions of the paramedics, again, being that they are the ones who injected Mr. McClain with ketamine. They are the ones who failed to assess Mr. McClain prior to the injection of ketamine. They are the ones who failed to properly assess the weight of Mr. Ketamine and thus gave him an excessive amount of a dose. And they are the ones who failed to monitor Mr. McClain after the injection of ketamine. The court also heard evidence criticizing the restraint by law enforcement. And that's also very important. That goes primarily towards my complicit argument. However, starting off, I think it's important for us to break it down by going by principal and complicit type arguments. And so if the people are attempting to show that the evidence is sufficient to proceed on the principal theory, that fails. There's been much discussion about the forcible restraint, as I mentioned, but as the court is aware, as the evidence has shown, Mr. Woodyard was not part of that restraint. Indeed, Mr. Woodyard walks away within mere seconds of Mr. McClain being restrained. And when Mr. Woodyard walked away, Mr. McClain was in the recovery position, as law enforcement is taught. That is part of Mr. Woodyard's training. And so when we look at the elements of manslaughter, when we look at the elements of criminally negligent homicide, both of them require a disregard of a risk. The mens rea for manslaughter, as the court is aware, is recklessly. And that and for recklessly, he must disregard a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Criminally negligence, so in terms of the criminal negligent homicide, through a gross deviation from the standard of care that a reasonable person would exercise, he fails to perceive a substantial unjustifiable risk that a result will occur, that a circumstance exists. So both mens rea requires an awareness of a risk. And this scenario, when Mr. Woodyard walks away from Mr. McClain, when he's ordered away, it's clear that he put him in the recovery position and there is no risk that is identifiable. Now, one individual has identified Mr. Woodyard as the person who applied a carotid hold. Indeed, there's a lack of evidence that a carotid hold was even successfully applied here. Through the body cam video, the court can surmise that there's an attempt made. However, there's contradicted evidence when the Officer Rosenblatt and Officer Redeem are discussing. They're not even sure if it took or if Mr. McClain had fallen or had been rendered unconscious. Instead, what we have is mere speculation that Mr. McClain may have gone unconscious. Dr. Sina testified, noted that there's no evidence of any injury to the neck that would suggest a successful application, or excuse me, a misapplication of the carotid hold. Dr. Mitchell discusses the petechia, but admits that that can occur from vomiting. So even if the court was to find that there's enough evidence to show that a carotid hold had been successfully applied, the court also has heard substantial testimony that the carotid hold is a safe maneuver, and that alone could not have caused Mr. McClain's death. Dr. Buther, the people's expert witness, took the stand and admitted to this. Dr. Sina, again, the people's expert, took the stand and admitted to this. Dr. Mitchell, again, people's expert, even admits to being unable to determine that the carotid hold itself would have killed Mr. McClain. And importantly, at the end of this trial, the jury will be instructed that they cannot base their decision on speculative evidence. So under a Rule 29 motion, the court also cannot make illogical leaps and bounds to assist the prosecution. At the end of the day, all the experts agree that ketamine is the cause of the death. Without the ketamine, we do not have death in this case. And so as a principal actor, it simply cannot be argued that Mr. Woodyard gave Mr. McClain ketamine. Indeed, the court also, for purposes of the principal actor theory, it also cannot be argued that Mr. Woodyard was involved in any restraint process that caused hypoxia or acidosis. Because as the court saw from Officer Dunson's camera, Mr. Woodyard walks away. Instead, it's Officer Rodema, Officer Rosenblatt, and then eventually Officer Green, who replaced Officer Rosenblatt. We also have Dr. Buther's handwritten chart as a demonstrative evidence that showed how Mr. McClain's health was, what Mr. McClain's health was while Mr. Woodyard was present. And during those periods of time, according to Dr. Buther's chart, he was healthy, he was active, he was talkative. When Mr. Woodyard was present, Mr. McClain was verbalizing, vocalizing, and in the recovery position. There is no risk that can be identified when Mr. Woodyard walked away that was consciously disregarded or failed to be perceived. Mr. Woodyard instead had followed his training and he had called medical personnel. As the court heard, law enforcement, they are not trained in medicine. They only have basic first aid. And so the only thing they can do is contact medical personnel. If the individual does not wake up, if they are unconscious, then sure, law enforcement can perform CPR. That's not applicable in this case. The court also heard that Mr. Woodyard is required to defer to medical for medical decisions. And so it cannot be said that Mr. Woodyard is the primary actor that caused Mr. McClain's death. And if it cannot be said that he's the principal, then they're stuck with trying to claim that he's part of a quote unquote team. And therefore he's responsible for any actions of those team members. That's simply not the case. That goes against the complicitor law. So moving on to complicity, as the court's aware, it requires the intent to aid, abet, advise, and encourage. What it doesn't require is that individuals simply be part of law enforcement and therefore they're complicit in any action by law enforcement. All the experts that have testified have failed to even identify Mr. Woodyard by name, but rather they identify all the actions of law enforcement as a whole. That does not pass the Childress requirements for complicity. Childress, Childress. I know the court's familiar with that case. And so in order for there to be complicity, as I mentioned, there has to be the intent to aid, abet, advise, or encourage the principal in his criminal act or conduct. And in addition, there must be an awareness of the circumstances attending the act or conduct he seeks to further, including a required mental state. So the complicity theory in this case, judges, is quite interesting. With the not guilty verdicts to manslaughter for Officers Rodema and Officer Rosenblatt, allowing the attorney generals to proceed under a complicity theory would quite literally be placing Mr. Woodyard in a position where he could be found guilty of complicity when the jury has acquitted the principals. So again, repeating that, Officer Rodema, Officer Rosenblatt have been found not guilty by juries of their peers of manslaughter. And so how are we going to allow Mr. Woodyard or the attorney generals to proceed under complicity by saying that he aided, abetted, advised, or encouraged the principals when there has already been a finding that they did not commit a criminal act, or that criminal act, specific one? With Officer Rosenblatt's not guilty verdicts to all charges, to allow the attorney generals to proceed on complicity would be placing Mr. Woodyard in a position where he could be found guilty under complicity when the jury acquitted Officer Rosenblatt on both manslaughter as well as criminally negligent homicide. And what's interesting is, unlike Officers Rosenblatt and Rodema, Mr. Woodyard was not present when medical personnel made the decision to utilize and inject ketamine. The arguments in the prior trial was that Officers Rosenblatt and Rodema aided, abetted, advised, or encouraged the paramedics to use ketamine by saying words like, when the paramedics had said, when the ambulance gets here, we'll give him ketamine, that Officer Rodema responded, perfect, dude, perfect. And Officer Rosenblatt responded, he had a crazy amount of strength. That can't be argued here. While they're able to get past the Rule 29 motion in Officer Rosenblatt and Rodema's matter by making those arguments, they simply can't make that argument here because Mr. Woodyard was not present and was not aware that the paramedics were intending on using ketamine on Mr. McClain. So if he was not aware of a circumstance that exists, how could Mr. Woodyard aid, abet, advise, or encourage the use of ketamine? I anticipate that the people will argue that Mr. Woodyard was complicit in the restraint by the law enforcement officers. However, we see from the evidence that he walks away mere seconds after Mr. McClain was placed in handcuffs and again in the recovery position. The people had shown still images to the jury of Mr. McClain that had fallen out of the recovery position and more towards the prone position. But what they didn't show the jury is any evidence that Mr. Woodyard was around when that occurred, or that Mr. Woodyard was aware that that occurred. Indeed, the people's own evidence shows Officer Rosenblatt advising medical personnel while Mr. Woodyard was gone that they're trying to keep Mr. McClain on his side in the recovery position, but Mr. McClain keeps fighting them to go into prone. There's also lots of arguments in the past against Mr. Rodema, that Mr. Rodema was applying force against Mr. McClain and thus impairing his ability to breathe and recover. They discussed a lot about how Mr. Rodema was body slamming or slamming Mr. McClain's body. Again, Mr. Woodyard was not present. How could he aid, advise, abet, or encourage that when he was unaware that it was occurring? This was all done without Mr. Woodyard's knowledge. He was not there when this was happening. Simply is no evidence that Mr. Woodyard was aware of any of the actions by Officer Rodema, Officer Rosenblatt, Officer Green, or any other officers that would cause hypoxia or acidosis under that theory. What's also interesting is that there has been no expert that can opine to a degree of medical certainty of the acidosis or hypoxia, given that there's no test. They can surmise, they can speculate, they can say there's a chance of that, but they can't say that it's to a degree of medical certainty. And so that then leads towards aspiration. Per training that Mr. Woodyard went through, we go back to the issue regarding the recovery position. That is all Mr. Woodyard is trained to do. He cannot stick a finger down an individual's throat. He cannot do any other movement or any other medical maneuver to an individual other than CPR, which would be medically incorrect in this situation. What I'll also note is that there is no evidence that Mr. McClain aspirated while Mr. Woodyard was present. Now, I imagine the people will argue that there's a possibility. With that possibility, however, there is no evidence that Mr. Woodyard is trained to identify that. Quite the opposite. There's been substantial testimony that these officers, that these law enforcement officers, they are not medical personnel, that they are not trained to detect the aspiration, that they are not trained to detect hypoxia or acidosis. All law enforcement can do is contact medical personnel. And all law enforcement can do is assist medical personnel if they are requested. If they are not requesting assistance, they are to stay out of medical personnel's way because it becomes they have medical control. All law enforcement can do is place Mr. McClain on his side. And that's what Officer Woodyard did. And he then contacted medical, and it becomes their scene. So in the end, Your Honor, even when we judge the evidence and view the evidence in the light most favorable to people, this no longer becomes a situation where we can draw reasonable inferences to guide them past Rule 29. Rather, we must make illogical leaps and bounds to connect the dots for them when the dots should not be connected, Judge. And so for those reasons, Your Honor, we're asking the court to grant our Rule 29 motion and to dismiss the manslaughter and criminal negligent homicide charges. Thank you.
Thank you. For the people.
Judge, having now sat through the evidence in this entire case, I won't go too deep into the individual evidence, but I did want to raise one novel issue that Mr. Ho brought up, indicating that the jury acquittal of the manslaughter charges in the Redeemer Rosenblatt case would somehow be binding or influential upon the decision here. And nothing could be further from the truth. And the statute, Colorado Revised Statutes 18, I'll let you grab your book, 18-1-605 is directly on point. 18-1-605 says, in relevant part, it is no defense that the other person has not been prosecuted for or convicted of any offense based upon the behavior in question, or has been convicted of a different offense or degree of offense, and it refers to any cases being prosecuted under theories in 18-1-601 through 604, and the complicity statute that people are relying upon can be found at 18-1-603. So this provision here is inclusive of the complicity statute that can be found at 18-1-603. So the fact that the jury in the other case, which listened to different evidence in different circumstances, decided on a different degree of offense here has no binding effect upon this case. It's not preclusive and should not guide the court's decision in making a ruling on this motion for a judgment of acquittal. Outside of that, Your Honor, I think that the people have clearly established all the relevant elements of the different crimes. We'll focus on the two that Mr. Ho focused on, recklessly or with criminal negligence, and then causing of death. I think that the recklessly or the deviation from standard of care in criminally negligent homicide could be demonstrated from a principal liability standpoint, purely based upon Mr. Woodyard ignoring his extensive training about what he was supposed to do when a subject that he was detaining said, "I can't breathe." And Elijah McClain told him that 6 times while aspirating in his mask and being held down after the carotid. They were provided with specific training scenarios with strikingly similar facts to those in this case, and yet did nothing to alert the paramedics about that danger. They were trained about the dangers of hypoxia, of acidosis, of holding a person in prone positions, exactly like the kind that Mr. Woodyard saw Mr. McClain being restrained in immediately before and after the administration of ketamine. In addition, Mr. Woodyard could be found to be complicit in adopting the reckless actions, both of the paramedics, as he knew that they were applying a sedative as he arrived on the scene, just as the ketamine was being brought up and administered, and agreed to help Mr. Redema when he said, once this medicine kicks in a minute here, Woody, Rosie, we're going to lift him up and move her onto the gurney, to which the defendant replied, yeah. As to cause of death, first, Mr. Woodyard can be found responsible for criminally negligent homicide or manslaughter because he set in motion a chain of events, the natural and probable result of which were the contribution to the risk of death. First is the failure to communicate to the paramedics the fact that Mr. McClain couldn't breathe, which was then the basis of all of the wrong decisions that came after that. Instead of treating this like a medical emergency where Mr. McClain's airway needed to be protected, instead, they go down the predictable route of treating this as a chemical sedation, which is ultimately what was chosen. Additionally, there's been extensive testimony that the carotid itself contributed to hypoxia, acidosis, and aspiration. Both Doctors Buther and Mitchell were clear that not only those things, but also the restraint position, which Mr. Woodyard affirmed once he was back on the scene, were incredibly dangerous and enhanced the likelihood that ketamine would be a contributing factor in Mr. McClain's death. So I think there's plenty of facts in the record for either a primary responsibility or a complicity theory that the jury could find and convict the defendant Woodyard of either manslaughter or criminally negligent homicide.
Court want a quick reply?
Go ahead, as long as it's quick.
Very quickly, Judge. It sounded to me like Mr. Slothauer was arguing proximate cause regarding the cause of death. And I think that's important to note here because proximate cause is not an element. And when we look at the Savardra case, Saaverdra, 971 Pacific 2nd, 223rd, when we're talking about criminal homicide, it requires proof beyond a reasonable doubt as a natural and probable consequence of the defendant's unlawful act. This is not a proximate cause case. This is an actual cause. And so it has to be related to Mr. Woodyard's actions, not other people's actions, unless we're proceeding by complicity theory. And so I think that's important under that Savardra case I'm more than likely mispronouncing it, but Savardra case that this is not proximate cause. This has to be an actual cause. Thank you, Judge.
All right, the matters before the court currently on a motion for judgment of acquittal pursuant to Rule 29 of the Colorado Rules of Criminal Procedure, in particular with respect to what are or counts 9 and 10 in the indictment. Count 9 is the reckless manslaughter count that charges between and including August 24, 2019 and 27th, 2019 in the state of Colorado that Mr. Woodyard did unlawfully, feloniously, and recklessly cause the death of Elijah McClain. The what the court has found to be a lesser included offense is in count number 10, criminally negligent homicide, again, with that same date range in Colorado that Mr. Woodyard unlawfully and feloniously caused the death of Mr. McClain by conduct amounting to criminal negligence. I'm not going to reiterate, I suppose, the definitions of reckless and criminally negligent. But here, the court does have to take into consideration the factors as set forth in the Bennett standards at 514 Pacific 2nd 466 that have been in effect for several decades in this state. And that is, first, the court must give the prosecution the benefit of every reasonable inference, which might fairly be drawn from the evidence. Second, the determination of the credibility of witnesses is solely within the province of the jury. And I will note that here, and I'm taking into consideration the, certainly the testimony of Dr. Sina, but also that of Dr. Buther and Dr. Mitchell, and that Dr. Mitchell was not equivocal in making his opinions to a reasonable degree of medical certainty concerning the hypoxia and acidosis that he believes he saw as did to a degree Dr. Buther. And it's really up to the jury to determine the credibility and weight of that testimony, which moves to the third factor, and that's the weight to be accorded to various pieces of evidence by resolving conflicts in the evidence. And clearly here, there has been. But that's not for the court to decide. It is ultimately for the jury. The people will note that when I was on the other side of the bench, the court was involved in a trial of People v. Wilkinson, where the court, that court dismissed a count of murder in the first degree. Ultimately, the Court of Appeals, I suppose, that judicial officer was in the same position this court is in today, and that is, I'm not supposed to be the 13th juror. The words, it is up to the jury to decide the weight and the credibility to the testimony and evidence. The evidence does have to be substantial and sufficient, and a modicum of relevant evidence will not rationally support a conviction beyond a reasonable doubt. And finally, that verdicts may not be based on guessing, speculation, or conjecture. The court does find that, I suppose, as a wise jurist once said, that law is not that of logic, but experience. And the argument with respect to the verdicts returned in the prior trial certainly has a logical approach, I suppose, to what the court should do in this particular situation. But I suppose the experience, that being that articulated 181605, really controls the court's decisions. The court will find that, again, there was testimony or the argument that presence or non-presence during certain parts of what were depicted on the body-worn cameras. The court would note that it was somewhat difficult to determine where everybody was, as certainly as was testified to, that when you're wearing your body camera, that doesn't necessarily A, depict what you're looking at or what you can see, and B, not necessarily what somebody could hear or overhear. The court does find that based upon the exhibits, there is evidence in the record that the officers were, in the course of their training, trained on hypoxia, and in particular how that might affect positional asphyxia, that I suppose to a certain degree here was discussed, in particular with the either partial or prone position that Mr. McClain was placed in at various points during the time he was held. Furthermore, there is evidence in the record that the court finds the jury could put weight on, and that was the has to do with the complaints of Mr. McClain that he couldn't breathe or he couldn't fix himself, which in the context, now whether or not specifically Mr. Woodyard could overhear, I suppose what has been argued were 7 complaints of being unable to breathe. Overheard 1 or more of them is really, again, a decision that the jury is ultimately going to have to make. The court will find that employing the standards as set forth in Bennett, the court will find that the evidence is sufficient for the case to go to the jury, in particular the case of the particular charge of reckless manslaughter that includes the count number 10, the lesser included offense of criminally negligent homicide. So the motion is denied. Should we talk about Dr. Cheryshenko now? The court, I'll tell you, I don't know how important the exhibits were that were supposedly attached to the motion, but I don't have them. But I did carefully go through everything that I have, which would include the report from August 1st of 2021, the grand jury testimony, as well as the updated report of October 25th of 2023. And I suppose, let me find my, okay, I think I'm ready to go with what I have anyway.
Those are the most important things.
Okay. Yeah, and the things that, a couple of the things that I just will observe is I note, and I'm quoting from the people's endorsement, and it is Dr. Cheryshenko will testify as an expert in the area of paramedic roles, protocols, training, and pre-hospital care. Testimony will include, but is not limited to, the opinions to which she testified at the grand jury, the opinion included in the transcript with her changes noted at Bates S40801 and the letter dealing with the changes, and the opinions expressed in her expert report dated August 1st of 2021. And really what the court is trying to focus on, I suppose, is what in looking at the Pronovost factors is what's the big surprise? And I'm reading from the report of August 1st, 2021 on page 8 toward the bottom, the penultimate paragraph. It is my opinion that these failures and deviations from the standard of care were a direct and proximal cause contributing to the death of Mr. Elijah McClain. It's hard for me to find that that's some kind of surprise.
Judge, we would agree with your with your analysis of that paragraph. I think that the thing that is really new is the entire subsection entitled aspiration. And that's, let me get the pages. And that's from the Cheryshenko report from October 25th, so just 5 days ago. And I'm referring specifically to page 5 is where it starts.
Yeah, I'm there.
So the things that I think are so new here are, first, this is the only time that Dr. Terashenko purports to analyze Mr. McClain's medical condition prior to the receipt of ketamine. The limited opinions that she offers regarding ketamine's effect on Mr. McClain in grand jury are just that the ketamine and the paramedics' negligence and recklessness in administering the ketamine contributed to his death. She doesn't purport to say, here was his condition before. And she definitely does not purport to say, in her initial opinion, that she disagrees with any other expert reports, as she does in this one, where she says, contrary to Dr. Buther's report. That's the thing that goes far beyond what she was retained to analyze, what she did analyze in grand jury, what she did testify about at grand jury. And we didn't even ask her to look into these issues. So this is what we think is the retained defense expert opinion. I have no idea why she put it into the supplement that we asked for regarding the paramedic experts. I don't know if that was directly at the defense's behest or she just got started writing and wanted to add that in. But this is all completely new information. Anything about Mr. McClain's medical condition prior to administration of ketamine goes beyond her grand jury testimony and would be a brand new, undisclosed, unendorsed opinion.
Okay. On behalf of Mr. Woodyard,
Your Honor, do you want me at the podium or is it okay to stay right here with all my?
as long as you have you can pull one of the microphones kind of close. It's partially for my benefit, and I'll argue that it's for the court reporters as well.
Very good. Your Honor, we are in a position where the objection to what is being characterized as something new, as best I can read, is coming under Rule 16. This is a very unusual circumstance where this particular witness was retained by the prosecution and is essentially their witness. And so this characterization that there's a retained.
What's the essential part that I need to learn a little bit more about? I don't need to know. I'm not asking, and I don't want to ask. But, the fact of the matter is, how many hours of the doctor's time has been spent, and I suppose paid for on behalf of your client.
Well, we're prepared to provide the court with whatever information is necessary for this analysis. But what I'll tell the court in response to that question is that the only materials that we are aware of that have been reviewed by Dr. Terashenko are materials that were provided to us by the prosecution. So there's nothing that we have provided that they don't have. It's simply a review of the discovery in the case.
I assumed that was probably the case, but then again, one thing I noted in her most recent report of October 25th is she twice in her opinion letter cites to the testimony of Dr. Sina, although that's not listed anywhere on her materials that she's reviewed.
Your Honor, what I can tell the court is we have not provided her any trial testimony. So it may be that she's referencing grand jury testimony, but what I can tell the court, and we have not given her anything that was not provided to us in discovery. And so I'm looking at her original report where I'm sort of baffled by this because she says in her initial report what she has reviewed. And they include, this is a pretty exhaustive list of materials that includes, I think, a bulk of the discovery items, including Dr. Buther's expert report, the original one. And I think she says grand jury testimony. I'm looking here to see if that
Not if
includes,
Dr. Sina.
that's what I was just looking for.
No, not on either. That's why I brought it up. I
So-
carefully checked that.
So she says, I mean, in the expert endorsement that we were provided, it reads that she is relying on these materials and then any other materials that may be provided to her. We can go back and check, because here's the situation. When we consulted with Dr. Terashenko as a prosecution witness, we recognized the fact that she was retained by the prosecution. And so we were told that she would need to check with them before even interviewing with us, which I think that they have accounted for in their motion. And then on her own behest, she agreed, as many experts do, to be available to us and answer questions and consult. We had endorsed her because her opinion, which frankly I don't think has changed, is exculpatory to Mr. Woodyard. And so I just want to be clear where we sit now. We started with an assertion by the prosecution that none of her testimony may be admissible. And I think right now we are discussing whether sort of the scope of her testimony, but as the court can see from her report, she attributes the cause of death to an improper administration of ketamine and a failure on the part of the paramedics, which is frankly the essence of our defense. And so when we read her initial report, it is clearly exculpatory. And that's why we reached out to her. We were not in a position that we thought it was appropriate to withhold any discovery materials from her. There's nothing new. There's no other materials that the prosecution would not have seen or been aware that were provided to her. But it does appear that she was not provided materials by the prosecution. So we have a situation where the prosecution is telling the court, we only endorsed her for this particular reason, and there's an endeavor to limit the scope of her testimony. And it appears that she was not provided discovery materials, and that when she is reviewing discovery materials, she's making additional exculpatory opinions as they apply to Mr. Woodyard.
But certainly outside the scope of her endorsement, which are protocols and procedures for paramedics.
Well, I don't know that I would agree with that, Your Honor, respectfully, because she is endorsed in pre-hospital care. And so if she has been asked to review, as she was, a number of police body camera videos, she says on here that she reviewed body-worn camera footage. There's a number of them from the different officers. She's reviewing, it seems like the entire time frame, and she's an expert in pre-hospital care. Well, pre-hospital care involves the condition of the patient, and frankly, all of the things that other experts have testified about. It's not necessarily related just to paramedic standards. It's sort of what may or may not be going on with a person that may or may not have been observed by the paramedics. She says in her original report, and I just found it, she talks on page 7 of her report, near the bottom of the page, that an overdose of ketamine is well known to cause respiratory depression and arrest. And ketamine, even at appropriate doses, can cause laryngospasm, emergence reaction, nausea, vomiting, and hypersalivation, and is expected to cause central nervous system depression. Well, she's talking about vomiting and things that are at issue in this case. She goes on to say, even when given in appropriate doses, close monitoring of the recipient's respiratory status and airway is imperative, as airway obstruction, aspiration, and respiratory arrest can occur. So part of her original report here includes an item of aspiration, and that can occur relative to ketamine. So therefore, the timing of that and whether it has occurred, she's clearly indicating aspiration in her original report. I think it's important to let the court know that this isn't a situation where we have asked her to write a new report for our use in the case. We are in a position where, as a product of her dealings with the prosecution, a report has been disclosed to us, which includes exculpatory information. That's still part and parcel of their expert disclosures. It is not a case where we are saying we want to endorse this expert for a new reason. We're in a position of receiving what is exculpatory information in a report written and disclosed to us by the prosecution as discovery in the case.
I'm following your argument, but it occurs to the court that if the tables were turned, so to speak, that you would be entitled to know what additional materials were provided to the expert. You said stuff that's in discovery, but I suppose that list could be pretty long.
Well, I think we can certainly address that. If
Well, that's what I'm asking.
we are looking through our email, because when we were consulting with this expert, she asked us to see other pieces of discovery, and we, frankly, I don't withhold evidence from experts. And so we provided her the amended autopsy report, which is in discovery. Looks like she asked for, and we provided Dr. Sina's CV and his grand jury testimony, which was also in discovery, not knowing what, if she had maybe not reviewed that before. We provided those 3 items.
All right. That's instructive. Go on with your previous argument.
So the other thing to point out to the court, as it concerns whether this is actually new information, is that in the prior report, when we go on to page 8,
Oh, sorry, I kind of, as I'm reading this, I missed something that maybe it's important. And that would be the May 23 report of Dr. Buther.
we did not, or we gave a supplement. The prosecution had not given the supplement.
So add that to the list.
Add that to the list.
Okay.
Yes. And Your Honor, I would have to, I mean, we'd have to like go through and just make sure if the court's ordering us to indicate what else she has reviewed, which I think is appropriate. I just want to make sure we give the court.
When was that sent to her?
I'm sorry?
When was that sent to her?
September 25th. Upon her request for additional materials, that we believed that because they were in the possession of the prosecution, we weren't giving her anything new or that they weren't aware of.
All you had to do is look at the list from the first report.
Well, I mean, her first report says that it wasn't, I read that first report to say that she reviewed the records and additional documents currently available. These include the following. And it was not my impression that she was not provided everything. We sort of assumed that she would have had access to all of the information by the prosecution. So when we were asked for it,
You know what that
did not
old
want
story about assume?
to. Fair enough. Well, the bottom line, Your Honor, is this. Her opinion, as it stood back in June of 2021, is very relevant and exculpatory. And for the purposes of the record, and I think that this report is in the record by virtue of the prosecution's filing yesterday. It's essentially corroborative of our theory of the defense. I mean, it goes to intervening cause, and it explains that, the dangers of ketamine, the failure to monitor, and that her opinion is that that is the cause of death. So upon reviewing this, it struck us as extremely important and critical to Mr. Woodyard's defense. we're in a position now where we are evaluating the fact that she is saying more. She's saying more about whether aspiration occurred prior in time and whether she agrees with other prosecution experts. And the analysis that we are undertaking is whether it is incumbent on the defense to know that and anticipate that and ask her to provide a report, or when a prosecution expert is saying these things, it makes me wonder, why were we not provided? And to be fair, I don't want to go too far here, but if they are limiting her review to avoid an exculpatory opinion that's helpful to Mr. Woodyard, and the defense is providing her additional access to discovery, and then we're getting reports that takes into account sort of a very exculpatory opinion because it varies from their other experts. It comes back to that question of, are we not allowed to present that in our defense because it was provided to us after discovery deadlines? Because as the court knows, the Rule 16 statutory deadlines are sort of subject to constitutional limitations. And when we get a report from a prosecution expert that takes into account, additional information that is exculpatory to a defendant, as the court knows, there is a different analysis when it is a defendant who's trying to present it, as it bears upon the constitutional right to present a defense, the right to a fair trial, constitutional due process rights. And so I'm just respectfully urging the court that it would be a profound violation of Mr. Woodyard's ability to present a defense if we're not allowed to ask an expert witness about this exculpatory information. I would also tell the court, I think it merits mentioning, that not every, but those two of the prosecution experts, Dr. Mitchell and Dr. Buther, went way beyond the scope of their reports. And so there is now an issue in the case about the timing of aspiration. Dr. Mitchell gave a play-by-play, clip-by-clip on video about all the different times aspiration occurred. He was presented with evidence for the first time in this trial where he reviewed a mask and gave an opinion that we heard for the first time. He is a properly endorsed expert witness who is allowed to opine on evidence in the case. And as the court knows, the purpose of these disclosures is to provide notice, but it doesn't necessarily include a verbatim rendition of an expert's report. So we're hearing for the first time in a trial that there was aspiration in the mask, there were aspiration during these different events prior to the ketamine. In Dr. Mitchell's report, he said that there may have been aspiration. Dr. Buther, again at trial, said, I wasn't provided this mask until later, and wrote a supplemental report. And then he's asked to expand upon it with video evidence, none of which is in his report. And so we have to be in a position to rebut some of this evidence. And there's case law that talks about when the prosecution introduces or opens the door to an item of evidence, here the timing of aspiration, it's an advantage to the prosecution to get to sort of limit the scope of expert testimony on that so that they can provide all of their experts about when aspiration occurred. But if there is an expert that they have that says, I don't agree with those, we're not allowed to present that because it's coming up post the disclosure deadlines. So I think that the court has to balance the constitutional factors here. We did not, they introduced the timing of aspiration beyond the scope of the original reports. We should be in a position to rebut it, particularly where they are on notice of it. So as the court knows, the intent of Rule 16 is to allow the prosecution sufficient meaningful information to conduct effective cross-examination. We are literally arguing about whether we can produce or elicit exculpatory information from their expert witness who wrote them a report on this. So there is no argument that they are not on notice of it. None. There is no argument that they are prejudiced by this. Mr. Woodyard will be substantially prejudiced if we're not allowed to present this defense when frankly, we did endorse this expert timely. We were always intending to ask her questions that they
Wait
know.
a minute, I thought I said 56 days before trial. Did I not?
We endorsed this expert. We said, we endorsed her as, we might have done a supplemental, but I think we endorsed all prosecution witnesses 56 days before trial. And I think we have an argument about whether it was 56 or 57 because we're arguing about the 24 hours difference. But again, Your Honor, the endorsing of experts is to provide them notice. And so if this was an expert that they were only getting notice of those 50, I guess it would be 55 days before trial, everything that we were endorsing about this expert is everything that was already in their possession. And so the idea of notice and us disclosing her, it doesn't quite, it's not quite the same when we're endorsing all of the information that they already have. It's nothing new. So I think that with respect to the constitutional implications here, the Rule 16, as the court knows, are statutory. We certainly respect this court's deadlines. We received this report last week. It is exculpatory for Mr. Woodyard, and they are now exactly on notice. And I think that they have ample access to Dr. Terashenko, who is clearly in communication with them and providing them notice of all of these things. And I would ask, Your Honor, to the extent the court would allow additional briefing on this, I have not, just because we received this particular, I suppose, motion.
We don't have time for that.
Well, just in terms
Starting
of,
testimony tomorrow.
well, just in terms of the provenance factors, or whether the court wants a more articulate sort of response as to these various factors. I have here under People v. Cobb, which is 962 P2D 944, the court has discretion in deciding the appropriate course of action in response to an alleged violation of Rule 16, which is what we're doing. And the factors laid out there discuss the reason for and degree of culpability associated with the violation, the extent of the resulting prejudice to the other party, any events after the violation that mitigate the prejudice, and reasonable and less drastic alternatives, and any other relevant facts. I think in any of the case law, and I haven't looked at these cases overnight in the hours we've had this, I would be surprised if any of these disputes relate to the defense calling a prosecution expert to ask about things that are all included in reports in the possession of the prosecution. So there is essentially no surprise here. And we got the report last Friday. I suspect that there was a conversation and she was asked to write a report, but we did not ask her to write that report. We did not ask for that information, but it has been provided to us. It is exculpatory and it is in their possession. And frankly, I don't think it's a far veering away from her original opinion when she's discussing risks of aspiration and what that is, and having reviewed all of that video footage. Where the final thing I'll say, Your Honor, if the court will permit me, is that the analysis here also impinges on whether the prejudice to Mr. Woodyard, if we are not allowed to ask this medical doctor her opinion that is helpful to him, whether that will prejudice him. And the limitation of expert testimony on behalf of the defense is recognized as a pretty severe sanction. I'm now citing Golub v. People, which is G-O-L-O-B. That case concerned slightly different issue, more going to the qualifications of the expert, but nonetheless, the court did not allow the defense to elicit expert testimony. And in that case, the court recognized that the trial court's ruling allowed the prosecution's testimony to stand unchallenged and resulted in an unfair advantage to the prosecution through the selective presentation of expert opinion to the jury on important evidence. So the court knows the question of aspiration here is material to the case. And so depriving Mr. Woodyard of the ability to ask this witness about her disagreement with it is substantial. And the standard upon appeal requires reversal unless a court is confident beyond a reasonable doubt that the error did not contribute to the guilty verdict. And so when we have a situation where we have been disclosed in discovery, a report prepared by the prosecution for a retained prosecution expert that is favorable to the defense, I frankly, Your Honor, I understand the Rule 16 requirements. I can't fathom the court disallowing that under these circumstances. It was written by their expert. They're on notice of it.
You never really answered my first question. Is
Sorry.
how many hours have you spent and paid for Dr. Tereshenko's assistance, if you will, or allowing that she might have charged for interviews?
I'm sorry, Your Honor, for interviews of,
The doctor and providing materials to her to review. Maybe she does it for free. I don't know.
we have compensated her for her time. I just want to be careful not to run afoul of any 1.6 obligations, but
I don't want to know what was
Yeah.
discussed necessarily, but you can, you know, she's going to be able to be asked her hourly rate and how much you've paid her.
we're pulling it up.
If I may, Judge, pursuant to Mr. Slaughauer had asked for that information, so I'd asked my staff to pull it. And so I was looking it up this morning, so I don't mean to be double teaming here.
That's okay.
So with respect to Ms. Tereshenko, we have spent $10,900 for her services. There's an extra $10,500 for court reservation testimony. So that doesn't require, that's not including, that doesn't include talking to her, interviewing with her.
Her hourly rate?
That I need to look up if you can give me a second. I believe it's. So her hourly rate is $400 an hour. Now it varies with testimony, but that doesn't apply yet because she hasn't testified.
Okay. Any reply from the people?
I mean, I want to be very clear that as far as this trial is concerned, Dr. Terashenko is not our witness. She was never going to be used for either of the police trials because she was retained only to analyze the paramedic standard of care. In a complex case with a lot of medical information, it is common, in fact, it is crucial good practice to keep experts in their lane so that people aren't trotting all over each other. And that's exactly what was communicated to her. That's what's in her initial report. It's what's in her grand jury testimony. It's even literally written in her contract that she is not allowed to opine outside of the area of paramedic standard of care. So as far as all of this new testimony about Mr. McClain's medical condition prior to the injection of ketamine, or as to her opinions about how accurate other doctors' analysis of Mr. McClain's medical condition are, this is not our witness. This is their retained expert that they, according to these calculations that they finally provided, have paid for at least 25 hours of her review of information and the equivalent of at least another 25 hours of work for reservations for her testimony. So at least the equivalent of 50 hours of her time has been paid for by the defense to provide these opinions. We did not ask her to analyze Dr. Buther's supplemental report. We didn't even give it to her. That was deliberate because that was not her job. Dr. Terashenko is a former paramedic who's now an ER doc and works in systems and is really an excellent expert to analyze how paramedics are doing in terms of whether they're following their standard of care in the field. We did not hire her to take a look at the body-worn camera footage and go through minutely and analyze what's happening to Mr. McClain's medical condition. And she never testified about that at grand jury. She never mentions that anywhere in her report. And the defense are the ones that are now providing her this new information, asking her for these new opinions. That's why the second paragraph of our motion, Your Honor, says Dr. Terashenko is essentially two people right now. She's two witnesses. There's one that she's been properly endorsed for, and then there's one that is brand new. So I think that given the late disclosure here, which especially given the caginess about what exactly they asked her for, I mean, I'm still personally just very curious how this paragraph about Dr. Buther ended up in the report that she was drafting for us on defense experts, because we certainly didn't send her that information and did not ask her to write that in that report. I don't know if the defense put her up to it or if she did it on her own, but the entire situation, Your Honor, feels like it was not following the court's order on disclosure, and certainly was a big surprise to us. So I think that given how things have developed here, it would be within the court's discretion to prohibit Dr. Terashenko from testifying entirely because of this violation. But that is not what we're asking for. As we said in our motion, even though that would be an appropriate sanction, the lesser sanction of just precluding her from offering opinions on these new areas of Elijah McClain's medical condition and of comment on other experts' testimony in the medical arena, I think is sufficient to cure the prejudice, which to us is substantial. We had no opportunity to prepare with our experts to address these brand new opinions from Dr. Terashenko. We had no opportunity to tailor our calling of witnesses or our strategy on direct or our opening statement to address these issues that were not disclosed. And even at this point in time, we've rested. So even if there was some way that we could gin up a new rebuttal expert witness in the next 3 days, we've already rested our case. And so the prejudice to us, if this information comes in, just cannot be cured and is very substantial. So the tailing end issue here is the timing of this. And by the timing, I mean the timing of Dr. Terashenko's testimony. I'm concerned about the possibility that we really don't have very many witnesses for the next 2 days, and then Dr. Terashenko just ends up coming in at the end. And I'm not sure whether that's going to be the case or not, but I think that that scenario where we end up taking most of this week off and just calling Dr. Tereshenko for the limited purpose of addressing these issues of paramedic standard of care that have already been addressed by Dr. Buther and Dr. Mitchell, who both agreed that the lack of monitoring was horrible, that the lack of assessment was horrible, and that Mr. McClain should never have been given ketamine, and he definitely shouldn't have been given 1.8 times the proper dose, and that the ketamine was a major factor in why he died. I don't know that Dr. Tereshenko actually provides any testimony that's not cumulative of that, unless she's allowed to offer these new opinions. If we're going to be having solid testimony through Thursday, that's one thing, but it really also, I think, would be prejudicial to the people to end up taking most of this week off so that the jury has the better part of a week to completely forget the evidence in the case, to potentially expose themselves to things in the outside world. And so we don't have an ask on that because I have no idea what the defense is planning to do, but it is another concern that's lingering out there. So I think at this point in time, though, we really do need clarity from the court on what the scope of Dr. Tereshenko's testimony will be, because that will substantially inform, I think, both the timing and schedule of trial and, of course, our preparation for her cross-examination. Oh, and we have copies of all of the exhibits that we attached in paper, if we may approach, since they can apparently come through electronically.
Well, are there any that are of particular importance?
Judge, I do think the unpublished case that we referred to is really quite useful. It's, if memory serves, Coronado, thank you. I knew it was a C. It's a very similar situation. Oh, there it is. And in Coronado, Your Honor, the defense endorsed an expert witness for a limited purpose. And then in the middle of trial, after the people had rested, just like in this case, suddenly there was an indication that that witness was going to expand the scope of their testimony. And the trial court in Coronado excluded that testimony. And the Court of Appeals found that that was a proper sanction for the late disclosure, particularly given that the people had no notice of that additional proposed testimony from the expert until after they'd rested their case. So I do have a copy of Coronado if you want.
Keep it for future reference, if nothing else. I was not able to pull up the appellate opinion on this one because it's a little too old. All right. Well, the court does find this is a situation where the expert witness, and it's difficult for me not to see the irony based upon the prior litigation with respect to the forensic pathologist for Mr. Woodyard. Certainly here, the court will find, and that these are just based upon my calculations. I don't know how people charge for trials. It sounds like everybody's a little bit different. I think Dr. Sina said $5,000 or something like that. But just using the figures of $10,900, that's 27.25 hours, which is, in terms of a highly complex civil case, that's not a lot, but for a case of this nature, the court can easily find that Dr. Tereshenko is really wearing two hats here. One that is for the prosecution, and the court severed the trials based upon Rule 13. The indictments all came in one indictment. So there was a motion to sever that the court granted, certainly to mitigate prejudice to the respective defendants. So in view of the fact that the court would find that Dr. Tereshenko is morphed for the purposes of this trial, really from a prosecution witness to a defense witness, I'm not discounting the fact that her original report and her original testimony from 2021 are clearly exculpatory, but the new opinions that appear to be based, and the court would find, are based in large part on submissions from the defense to her, perhaps one of the more important ones on September 25th, which is roughly 2.5 3 weeks before the trial started in this case, as we started our jury selection process, if you will, on the 13th of October. The court would find that with respect to the factor one of the Pronovost factors, that there is some degree the court would find it to be moderate to slightly moderate. The next factor the court has to look at is whether in the extent of prejudice in trial preparation for the people based upon these new opinions that really kind of, I suppose, are contrary to the opinions of the people's other experts. That's substantial and significant. The events occurring after the noncompliance, there's, I suppose, to the extent that they've been provided, the people have been provided with some of the material submitted to Dr. Tereshenko in preparation for her defense testimony, that it's mitigated to a certain degree. And the court has to also look at the less drastic alternatives than just completely gutting her opinions with respect to Dr. Buther's report and her observations of the video cameras and such. The court would find that, and I'm starting on, it's page 5 under the heading of aspiration in the new report, that the first paragraph, I don't see any prejudice in really allowing Dr. Tereshenko to testify to what's in paragraph 1, is that really has been ferreted out previously. With respect to paragraph 2, the court's going to excise the first sentence. That's contrary to Dr. Buther's report, because that wasn't even given to her until September 25th. And there's nothing additional in the endorsement that would suggest that she's some sort of pulmonary expert, but this has more to do with aspiration. If you go down to the 5th line, after we get the first sentence that will be excluded, the sentence, the paragraph that I'm going to allow starts with, although anytime one has emesis, there is a risk of aspiration. Down to line 5, people can cough, gag, and clear their throat to avoid aspiration. I'm good up to there, but the part that starts with, we clearly see Mr. McClain doing such things in the body-worn camera footage, that's out. Paragraph 3 starts with, once Mr. McClain was given ketamine, et cetera, et cetera. I'm okay with that, with the exception of Dr. Sina supports this in his testimony. As there's nothing in the record to suggest that that was ever provided to her, at least by the original retaining counsel. Paragraph 4, it starts with, while certain cases of aspiration can cause sudden and near immediate respiratory and cardiac arrest, those are typically seen in aspiration events that cause sudden complete airway occlusion and not with fluid aspiration into the lungs themselves. I'm okay with that. The rest is out. And I'll allow the first sentence in paragraph 5. That's my less drastic alternative. Do I need to clarify?
Let me just confirm with you to make sure.
Okay.
Give us 1 second. So if I understand correctly, in terms of page 5 labeled aspiration, first paragraph that starts with there was without question, that's good.
Yep.
Thank you, appreciate it. And then the first sentence of the second paragraph, contrary to Dr. Buther's report, that's out.
That's out. And then we are all the way down to line 5 of that paragraph where it says gag and clear their throat to avoid aspiration, period.
That's okay. So although anytime anyone has emesis all the way down to gag and clear their throat to avoid aspiration, that's okay.
Yeah, I'm okay with that.
And then the next sentence, we clearly see that's out all the way to the end of the paragraph.
Are we on paragraph 3 now?
Sorry, for the second paragraph, just finishing out that paragraph where it starts. So you had said it's okay to end with gag and clear their throat to avoid aspiration. The next sentence that starts, we clearly see in Mr.
That's out.
That entire stuff is out until the end of the paragraph.
Correct.
Then the third paragraph is okay, except for the last sentence that starts with Dr. Sina also supports this in his testimony.
Yes.
And then the fourth paragraph, first sentence is okay. That starts while certain cases of aspiration. That's okay. The second sentence starting, it is clear from the intubation video that is not okay.
Correct.
And then the last paragraph on page, or I guess the first paragraph on page 6, that's okay.
No, at the first sentence of that paragraph is okay.
And then so starting at however death from aspiration, that's out.
Correct.
And Your Honor, understanding the court's ruling, I guess I'm just concerned overall procedurally because with 2 experts, the prosecution was allowed to publish video exhibits and have them give a play-by-play medical narrative that is not contained in any reports specifically that were disclosed to us. But then with an expert that we wanted to call who had been properly endorsed, because she wrote a report talking about.
Well, I'm not conceding that she was properly endorsed.
Well, to be clear, an expert who was endorsed by the prosecution had been
And,
working with them.
and is retained by you and your client.
So because she provided a report at their request detailing some of these things in advance.
That should have been disclosed by you.
But this is my point, Your Honor. We didn't have that in their expert reports. Does that make sense? So Dr. Mitchell's report didn't include, I mean, they're saying that we have caused this late disclosure.
Okay,
What it-
well, you may disagree with my least drastic alternative, but that's what I've decided.
I understand. I will not press the court further, but just for purposes of the constitutional record. When we present our witnesses, I want to make sure we understand the court's ruling with respect to these specific objections. But we are going to be asking for the same leeway to present a defense and allow them to comment on evidence in the courtroom, comment on the publication of video evidence in the exact same manner that that Mr. Woodyard has been prosecuted.
Okay, let me make it clear. I've decided the least drastic alternative.
Understood. I understand with respect to this witness. I just mean generally speaking. I just want to make sure that we're not limited in scope in other arenas. I'm not further challenging or arguing with the court on this ruling, but I just want to make that record that if we continue to be limited in scope, the constitutional deprivation of a fair trial is, I think, getting very palpable. So I just make that record as we wade into presentation of other potential experts and other potential witnesses. So
The
that's,
court certainly understands the constitutional implications of presenting a defense on behalf of one accused of a criminal offense. But as our appellate courts have repeatedly noted, that is within the bounds of the rules of criminal procedure and the rules of evidence.
I think there's a sizable difference in the disclosures that the defense has made for Doctors Arnall, Mr. Priest, and now Dr. Terashenko with the people's medical expert disclosures, which included disclosure of extensive grand jury testimony that included a lot of detailed reference to specific incidents. But most importantly, we also re-endorsed all of our experts and included their testimony from the Redeemer Rosenblatt trial as part of their expert endorsement. So there was an even more notice about all of the specific opinions. So I don't think it's apples to apples to say that Dr. Arnall and his brief report has been endorsed in the same way that Dr. Mitchell had with his report, grand jury testimony, and trial testimony. But that's just for the appellate record.
Okay, I probably should have mentioned that, but I figured it was kind of obvious from the record.
well, and that trial testimony was also a couple weeks before we started, and here we are. So
I understand.
And Judge, would it be okay with the court, just since we don't have a copy today? I imagine, I'm envisioning, just for purpose of the appellate record, if I can bring in a clean copy of Dr. Terashenko's supplemental report that she drafted for the Attorney General on October 25th. I imagine highlighting it.
I'll make a finding as a matter of logic and law that this may have been prepared by the people, but with significant input for Mr. Woodyard. 29 or 27.25 hours worth.
Okay, well, I don't think that's, regardless. In any event, what I'm envisioning is, I don't know how to do this, but I could probably highlight it with two different colors on what's in and what's out, and just to
Yeah, that's fine. And my suggestion would be run that past opposing counsel. And I've got mine kind of highlighted. I've made some changes after I listened to the arguments, to be honest with you. I wasn't sure where I was going to end up, but because I didn't have all the information.
That phrasing from Mr. Ho makes me realize that there's another issue related to Dr. Terashenko's testimony. This should not be referred to as our report, and she should not be referred to as our witness. I think that, first of all, it's extremely misleading. We did not ask her to prepare this opinion, and we didn't pay for it. They did. But more importantly, getting into the whose witness is she is the purest form of 403, because we would have to.
If they're calling Dr. Terashenko as a witness, it is their witness for their case in chief. What else?
just so the record is clear, Your Honor, because the court keeps referencing the time she spent with the defense. The time was reviewing discovery materials provided to us by the prosecution. So I just think that's an important thing to be clear on the record, that there wasn't anything additive other than
Well,
materials already in the possession of the
I think,
prosecution.
well, that's fair enough, but I don't need to go into the specifics of things because I'm not allowed to. But that's a significant amount of time, whether it's just reviewing materials or whatever, in particular based upon the endorsement of this witness in a really, what the court would conclude would be a fairly narrow area. despite the inclusion of the language of pre-hospital care or whatever it was. Let me see. Oh, pre-hospital care, which really falls within the ambit of paramedic sort of care. Because it does say care and not diagnoses. All right, what else?
The only other issue which we are prepared to address now or later is jury instructions. We haven't received any from the defense, so obviously after they conclude their case, we're going to have to talk about some specific ones, but we could potentially make some progress on others. I'm just thinking that if Dr. Tarashenko does testify on Thursday, depending on how long she goes, I don't know what the court's plan is for closings and jury instruction deliberation, but I would hate to have it be a situation where, we spend Thursday on Dr. Tarashenko and jury instructions go into Friday, we close midday or afternoon Friday, and then suddenly the jury has to go off to the weekend without even getting a chance to start deliberating. So I think to the extent it's possible to take care of as many of these issues ahead of time as possible, I think that would be the best for their time.
Um, All right, can we get everybody on the annotated proposed instructions from the people?
Yes.
On the first one, unless something drastically changes, other than domestic relations trials, I'm generally try not to ask questions of witnesses because it can be spun that I'm, I suppose, acting as an advocate for one side or the other. So I'm tried to avoid it in this case, and I intend to, but we can probably take that out. But any other objections on behalf of Mr. Woodyard to that instruction?
Not this time, Judge.
Okay. The second page. Um, Any objection to that?
Sorry, let's see. I don't believe so at this time, no.
All right, number 3 is I suppose, the new version of beyond reasonable doubt and the burden of proof, on behalf of Mr. Woodyard on that one.
Judge, it'd be our request to use the old instruction on the definition of reasonable doubt or proof beyond a reasonable doubt.
All right, any counter argument on behalf of the people?
This is obviously the updated Colgy instruction. I think that the committee chose to use this definition through a thoughtful, deliberative process. Obviously, I don't think either instruction is error, but this is, I think, the way that things are going to go in the future. And I think the instruction is just clearer and more easy to understand. I think that's why it's been moved to this one. So we'd ask for the new one, although neither one is erroneous.
All right, well, the court would, I suppose, find that what I'll call the old instruction has been on the books for many years, but almost every of the 20 years I was on the jury instruction committee, there were different suggestions to change it because a lot of folks found it to be difficult to interpret. And I couple that with at least in our Fourth Circuit and the United States District, they not only A, do not have an instruction on reasonable doubt, but B, even if asked by the jury, are not required to give one. So a reasonable doubt is reasonable doubt. I don't think this muddies the waters any, so I plan on giving that one. The next one is the credibility instruction that kind of morphs in, if you will, the expert testimony along with the number of witnesses.
No objection at this time.
Number 5, we'll wait and see. And the next is direct and circumstantial evidence.
No objection.
Next is the meeting with witnesses.
And Judge, I don't think we would be requesting that one in this trial.
Okay, well, I guess we'll just kind of hold that one off to see if it becomes relevant. I don't know. I don't think I've taken judicial notice of anything yet.
I never saw this this instruction about meeting with a witness before.
Oh, I forget. You have to look at the annotated version to figure out where that one came from.
It's a Seventh Circuit pattern jury instruction. But like I said, I don't think we're asking for it right now.
All right, we'll skip page 8 for the time being, and did I take judicial notice of anything? I don't recall.
So
Not yet, Your
I
Honor.
think so, okay. All right, limited purpose, yes, there may be, but we'll keep that one on the shelf.
we had done that with some of the body cam.
All right. Next is the definitions of reckless and criminal negligence. Seems pretty
No objections.
to the point. The next one, I'm trying to figure this out.
I think this was left over from the last trial.
So do I.
It does appear to be the case.
I mean, I suppose if there might be some lesser not included or something that are tossed into the mix at some point in time. I don't know. But yeah, we'll just leave that one. Um,
I think that on page 11, we could remove bodily injury and remove serious bodily injury and just leave conduct and omission.
I'd object to that. What's the theory with the omission?
All right. Well, I'm fine with taking bodily injury out and serious bodily injury out. We'll discuss whether to take, conduct that certainly goes in. The omission, I'll wait on that. Next, we have excessive force.
Yeah, Judge, we'd object to that. This looks like it's patterned after 8-803 SP, which is an excessive force instruction under 18-8-803 subsection 2. I believe when you even, so A, I don't believe it's relevant here. But B, I think even when we read the instruction that they took this from, it requires a reading of the provisions of 18-1707, which I don't see on here.
All right. I wasn't sure. I was relatively comfortable with the 707 version that we used in the last trial, but I don't see that in the packet.
That would be a defense they would have to request, is why it's not in the packet. Maybe they won't.
Yeah, I thought you may be doing that, and I think we're probably getting to that time where if you submitted any under seal?
Not yet, Your Honor.
Okay, well, it's probably time, so I can at least start looking at them to weave it into like this one. So I guess we'll just hold off on this one for a bit. The manslaughter looks. It's page 13. That looks okay to me.
Judge, we'd ask that element number 1 be changed from the defendant to Mr. Woodyard.
And I'm okay with either doing that or that the defendant, comma, Mr. Woodyard.
And I guess I would go down to the first paragraph of, or I guess first and second paragraph of find Mr. Woodyard guilty or not guilty of manslaughter.
Any objection to that?
No, we can insert Mr. Woodyard's name.
Okay. Then we have the LIO of criminal negligence, presumably making the same changes, I guess.
Thank you, Judge.
Maybe I should look at the annotated versions. Okay, the next one, Ron, I decided to move to the annotated version so I can try to deal with the controversial ones, I guess. Mr. Woodyard's position with respect to the cause definition.
Okay, so Judge.
Pardon me?
If I could have just 1 second.
Okay, sure.
Judge, I guess the issue that I'm having with this, correct me if I'm wrong, I don't think this is Colgy. This is just kind of piecemeal from different cases, correct? So, I mean, I guess,
Well, I think it's a little bit dependent on what definition we use, on whether or not Mr. Woodyard is going to be asking for a intervening cause instruction. Because I think once that's into the mix, we kind of have to define that.
okay. I guess when the court was saying that we should submit ours under seal, is it just to the court or just not the public seeing it?
That would be to me, but I'm not going to tell you folks how to do your job, but I think there are certain instructions that will likely be requested on behalf of Mr. Woodyard. If you think you're giving away trade secrets by revealing them to the prosecution, you can keep them under seal just to me, but that's up to you. But I think we could get through this process a little bit quicker if you do feel comfortable in sharing any of those requests, but I can't do so right now.
I guess the concern that I have with this instruction here is it doesn't appear to be Colgy. It appears to be piecemeal by different cases along with some, I think maybe civil Colgy instructions, but parts of it, not the entire instruction. It seems to unduly emphasize the prosecutor's theory as well as certain evidence of theirs. I think it also puts us in a difficult position then to be able to argue that Mr. Woodyard did not cause the death, but rather it was the ketamine. I guess when I'll make the record that I normally receive when I try to submit case law is for jury instructions, and under Gill v. People 139 Colorado 401, mere abstract statements of law or excerpts from court opinions generally should not be given as instructions, and so that's what I normally receive when I attempt to do it. So
Yeah, I know that case quite well, and I suppose I've tried to figure out over the last 30 years what is abstract and what is not, but reasonable minds differ on that. So I think probably we best kind of hold off on this based upon whether or not there is going to be a request for intervening cause, because I think that could be dispositive in one regard. It might be dispositive as to whether or not this particular instruction might need to be altered a bit to fit what has been generally accepted as an intervening cause instruction.
that makes sense.
And we have the complicity for the reckless with the or the instruction that follows, and the same thing for the lesser included of crim neg. This looks like it's based upon the post-Childress instructions.
So obviously we would object to the complicity instruction, assuming the court overrules that objection. Understanding the first sentence has a defendant, I think that's appropriate, but after that, I'd request that when it's the defendant, it be Mr. Woodyard.
Oh, sorry.
Sure. It says for manslaughter, reckless, a defendant may be either principal or complicit. I think that's fine there. However, when we get to the third paragraph, for the defendant, I would request for Mr. Woodyard to be found guilty as a complicit of the crime.
No, I'm okay with that, or for the defendant, comma, Mr. Woodyard, comma, either way.
We can do that.
All right.
When we're talking about that crime for element number 2, I'd request that be for manslaughter, for the crime of manslaughter, like it was in element 1. So it would be for 2, 3, and 4.
What's the prosecution think of that idea?
So paragraph 2 or number 2 would read, Mr. Woodyard with the desire or the purpose to design to aid or design to aid, abet, advise, or encourage the other person or persons in planning or committing manslaughter.
Correct.
I don't know that that's technically incorrect, since we have one count under the theory of reckless and the lesser with criminal negligence, but
I think presumably we would then have to modify what's at page 20, the complicity instruction for criminally negligent homicide, to then
Right.
repeat it. It just seems clunky to me to keep repeat, especially once we get to criminally negligent homicide. It just seems very clunky to be repeating it over and over. It's like if I introduce myself as Jason and Jason thinks this and Jason does that instead of ever using pronouns, but
well, I'm the one that has to read them, so I'm okay with it.
so sorry, Mr. Ho, in numbers 2, numbers 3, is there another spot?
4, please.
Oh, yep, 4. See. Sounds good.
Okay, rest of the ones I'm looking at are pretty non-controversial. I'm looking at pages 23, 24, and 25 is the only thing I'm going to ask, is that the final paragraph be eliminated. The only reason I say that is what happens is I take the original question from the jury, and typically I respond with a jury instruction of one sort or another, and just attach it for the record to my answer. So, and then I make copies for counsel of both the question and the instruction that I intend to give. So I think for purposes of keeping the record, that'll take care of it. I don't have to send back the question to them. I just send them the answer typically.
Judge, I'm assuming we're, well, I guess we have to be holding another formal jury instruction conference.
Oh, of course.
I would like to address the complicity, whether it should be allowed or not.
Right. I assumed that might be the case, but some of these I think we can deal with today, but some of them obviously I need to wait and hear what all the evidence is.
Your Honor, just to clarify, that was the last paragraph on page 25.
Yes, I'm sorry, and I'm on the, I switched to the annotated version, so
For the finally, please be sure to take
yes,
that out.
yeah, take that out. You can take out 26 as well. I do that, but I paraphrase it. 27 looks like. Oh, for page 27? I just need you to add to the first paragraph. It should read, the way I like to do it, quite frankly, is to read them all at the same time. So it should read, at the conclusion of closing argument, the court's judicial assistant will escort you to the jury room. All right, what else?
Nothing else from the people, Your Honor.
Well, I'll go ahead and do this. As I indicated earlier, the court will typically give the courteous advisal at this time after the close of the people's case in chief, but will allow, of course, Mr. Woodyard to make that decision after he's heard all the evidence. So I just need you to listen to the concepts I'm trying to explain to you. Is that you do have a right to testify in this case, as it is your case. If you want to testify, nobody can prevent you from doing so. You may take the stand and testify even if it's against the advice of your lawyer. If you do testify, the prosecution will be able to cross-examine you. You also have the constitutional right not to testify if that's what you decide. And if you don't testify, the jury will be instructed about that right, that they can draw no inference of guilt from that decision. It may not prejudice you in any way, and they cannot use that decision as evidence of anything. The decision on whether or not to testify is one that ultimately you have to make, and you can listen to what your attorneys suggest to you, but it's your personal decision, and you can make whatever decision you decide, even if it's against the advice of your lawyers. So keep that in mind, and I'll be going over that again with you later in the trial, Mr. Woodyard. All right, I guess we can be in recess. We'll see you folks tomorrow at 8:40-ish, I guess.